Here is a surprising reality about the Constitution that many Americans don't realize. For most of our nation's history, the Second Amendment did not restrict state governments at all. For more than 140 years after the Bill of Rights was ratified, the Supreme Court held that the protections in the first 8 amendments applied only to the federal government. That means a state legislature in 1820 or 1860 or even 1900 could regulate firearms in ways that would have been unconstitutional if Congress had tried the same thing. It wasn't until the 21st century that the Supreme Court definitively ruled that the Second Amendment limits state power. That single shift transformed the constitutional landscape. So here's the question I want you to think about as we begin. Should the Constitution impose uniform national limits on state gun laws? Or should individual states have broader authority to decide for themselves? I want you to share your answer in the comments, because that tension between national rights and state authority is at the heart of this entire discussion. Now let's step back and understand how we got here. The Second Amendment is short, but it has generated more constitutional litigation in the last 15 years than perhaps at any other point in American history. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. For most of the 20th century, federal courts interpreted that language narrowly. Many lower courts treated the amendment as connected primarily to militia service rather than to an individual right to possess firearms for personal use. But before we even reach interpretation, there is a deeper constitutional structure that matters: federalism. The United States was founded on a system in which the federal government has limited, enumerated powers, and the states retain what are often called police powers. Those police powers include authority over public safety, criminal law, and health regulations. Gun regulation historically fell squarely within that state authority. In 1833, in Barron v. Baltimore, the Supreme Court held that the Bill of Rights limited only the federal government. That meant that if a state restricted speech, imposed a particular criminal procedure, or regulated weapons, the federal Constitution offered no remedy. State constitutions provided protections, but the Federal Bill of Rights did not apply. That changed gradually after the Civil War with the ratification of the 14th Amendment in 1868. The 14th Amendment declares that no state shall deprive any person of life, liberty, or property without due process of law. Over time, the Supreme Court interpreted that clause to incorporate most of the protections in the Bill of Rights against the states. This process is known as selective incorporation. The First Amendment was incorporated. The Fourth Amendment was incorporated. The Sixth Amendment's right to counsel was incorporated. But for decades, the Second Amendment remained in a kind of constitutional limbo. In 1876, in United States v. Cruikshank, the Supreme Court stated that the Second Amendment means no more than that it shall not be infringed by Congress. That statement effectively confirmed that states were not bound by it. Later decisions echoed that understanding. So for more than a century, if a state passed strict gun control measures, the only constitutional limit would be its own state constitution. That modern shift began in 2008 with District of Columbia v. Heller. In Heller, the Supreme Court held for the first time that the Second Amendment protects an individual right to possess a firearm unconnected with militia service, particularly for self-defense within the home. The case involved a federal enclave, the District of Columbia, so technically it addressed federal, not state, authority. Heller struck down a handgun ban and a requirement that firearms in the home be kept inoperable. But Justice Scalia's majority opinion included important language. The court emphasized that the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever, in any manner whatsoever, for whatever purpose. The court identified long-standing prohibitions, such as bans on possession by felons or the mentally ill, laws forbidding firearms in sensitive places like schools and government buildings, and conditions on commercial sales, as presumptively lawful. 2 years later came the decision that fundamentally altered state authority, McDonald v. City of Chicago. In McDonald, the Supreme Court held that the Second Amendment applies to the states through the 14th Amendment. In other words, States are now constitutionally bound by the same core protection recognized in Heller. This was a constitutional turning point. It meant that state gun laws were no longer shielded by federalism alone. They were subject to federal constitutional scrutiny. From that moment forward, the constitutional limits on state gun laws became a live and evolving issue. After McDonald, lower courts across the country faced a flood of litigation. States had long-standing regulations, assault weapon bans, magazine capacity limits, licensing requirements, concealed carry restrictions, and courts had to determine how to evaluate them. For about a decade, most federal appellate courts applied a two-step framework. First, they asked whether the challenged law burdened conduct protected by the Second Amendment. Second, if it did, they applied some form of means-end scrutiny, often intermediate scrutiny. Under intermediate scrutiny, a law would be upheld if it furthered an important government interest in a way that was substantially related to that interest. Public safety, preventing gun violence, and reducing crime were typically recognized as important governmental interests. Many regulations survived under that analysis. Then, in 2022, the Supreme Court dramatically reshaped the methodology in New York State Rifle and Pistol Association versus Bruin. Bruin addressed New York's requirement that applicants show proper cause to obtain a license to carry a concealed handgun in public. The court held that the Second Amendment protects an individual's right to carry a handgun for self-defense outside the home, and that New York's discretionary proper cause standard violated that right. But Bruin did more than strike down one state law. It rejected the two-step means-end scrutiny approach that most lower courts had adopted. Instead, the court announced a new framework. When the Second Amendment's plain text covers an individual's conduct, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearm regulation. That language has become the central constitutional test. Under Bruin, courts are no longer supposed to balance public safety against individual rights in the traditional way. Instead, they must ask whether there is a historical analog, particularly from the founding era or Reconstruction, that supports the regulation. This has enormous implications for state authority. Imagine a state legislature passes a modern law limiting high-capacity magazines. Under the pre-Bruin framework, courts would weigh empirical evidence, legislative findings, and public safety concerns. Under Bruin, the question shifts. Were there similar regulations in the late 18th or 19th century? Is there a historical tradition of restricting particularly dangerous weapons? This historical inquiry is complex and often contested. Historians disagree. Lawyers argue over which period matters more: 1791, when the Second Amendment was ratified, or 1868, when the 14th Amendment was ratified. Courts are divided on how broadly to interpret historical analogs. And this is where the constitutional limits on state gun laws become especially nuanced. States still retain police powers. They can regulate for public safety. But those regulations must fit within a historical tradition of firearm regulation. For example, many states prohibit possession of firearms by convicted felons. Such prohibitions have largely been upheld even after Bruin, on the theory that there is a long-standing tradition of disarming individuals deemed dangerous or outside the political community. Similarly, restrictions on carrying firearms in sensitive places, schools, courthouses, legislative assemblies, have generally survived because historical evidence shows that certain locations were subject to weapons prohibitions. But not every modern law has a clear historical counterpart. Consider state assault weapon bans. Several states, including California and New York, have enacted prohibitions on certain semi-automatic rifles. Supporters argue that these weapons are unusually dangerous and associated with mass shootings. Opponents argue that they are in common use for lawful purposes, and that Bruin and Heller protect arms in common use. Lower courts have split on these questions. Some have upheld such bans, reasoning that states historically regulated particularly dangerous weapons. Others have found insufficient historical analogs and struck them down. Now let's pause for a moment and consider a real-world scenario. Imagine you live in a state that requires a permit to carry a handgun in public. You apply, meet the objective criteria, pass a background check, and receive your license. Then the state passes a new law dramatically expanding sensitive places to include public transportation, parks, entertainment venues, and even certain commercial establishments. Is that constitutional? Under Bruin, the state would need to demonstrate a historical tradition supporting those restrictions. Courts would analyze whether historical laws prohibited firearms in analogous public spaces. The analysis becomes granular, historical, and often contentious. This illustrates something critical. The Constitution does not categorically forbid state gun regulation, but it does constrain how far states can go. Another important limit arises from the concept of common use, articulated in Heller. The court stated that the Second Amendment protects weapons in common use for lawful purposes. That phrase has become central in litigation over bans on certain firearms or accessories. If a weapon is widely owned by law-abiding citizens for lawful purposes, courts may find that banning it violates the Second Amendment. But determining what counts as common use is not always straightforward. Does it require millions of units in circulation? A certain percentage of households? The court has not provided a precise numerical threshold. At the same time, Heller reaffirmed that dangerous and unusual weapons may be restricted. The challenge lies in defining what qualifies as both dangerous and unusual in a modern context. There is also an important distinction between possession and commercial regulation. States often regulate the sale of firearms through licensing requirements, waiting periods, background checks, and record-keeping mandates. Many of these regulations have survived constitutional challenges, particularly where they do not prevent law-abiding citizens from ultimately acquiring firearms. But again, after Bruin, the historical analysis becomes central. States must show that such regulations align with historical practices. Let's address a common misconception. Some people believe that Bruin or Heller eliminated virtually all state authority over guns. That is not accurate. The Supreme Court has consistently stated that the right is not unlimited. States may still regulate in ways consistent with historical tradition. Another misconception is that states can ignore the Second Amendment if they believe public safety demands it. That is also incorrect. The Constitution is the supreme law of the land. When the Supreme Court interprets it, that interpretation binds state governments. This brings us back to federalism. The 10th Amendment reserves powers not delegated to the federal government to the states or the people. But the 14th Amendment altered the federal-state balance. It imposed substantive limits on state authority, including the protection of fundamental rights. So the constitutional limits on state gun laws arise not from distrust of states per se, but from the post-Civil War transformation of American constitutional law. There is also a procedural dimension worth mentioning. Many challenges to state gun laws are brought under 42 U.S.C., paragraph 1983, a federal statute that allows individuals to sue state officials for violations of constitutional rights. This means that state gun regulations are frequently tested in federal court, often leading to nationwide implications. Now I want to invite you into the debate more directly. Do you think courts are well equipped to conduct detailed historical analyses about firearm regulations from the 1700s and 1800s? Or should legislatures have more flexibility to respond to modern technological developments and contemporary public safety concerns? Share your thoughts in the comments. This is one of the most significant jurisprudential debates of our time. Critics of the Bruin framework argue that it ties modern policymaking to incomplete historical records. They contend that the founders could not have anticipated modern semi-automatic weapons, urban density, or contemporary crime patterns. Supporters respond that constitutional rights are not subject to shifting policy preferences, and that anchoring interpretation in history prevents judicial balancing from eroding enumerated rights. Both perspectives raise serious constitutional considerations. Another evolving area involves so-called red flag laws, or extreme risk protection orders. These laws allow courts to temporarily remove firearms from individuals deemed to pose a significant risk to themselves or others, often based on a judicial finding supported by evidence. Challenges to these laws often focus not only on the Second Amendment, but also on due process under the 14th Amendment. Courts evaluating these statutes must consider historical analogs, procedural safeguards, and the balance between individual rights and public safety. And here is an important practical reminder. If you are personally affected by a state gun regulation, consult a qualified attorney licensed in your jurisdiction. Constitutional law is complex and fact-specific. This discussion is educational and analytical, not legal advice. As litigation continues, the Supreme Court may refine its approach. Lower courts are still interpreting Bruin, and further decisions will likely clarify unresolved questions. But three structural principles remain clear. First, states retain significant authority to regulate firearms under their police powers. Second, that authority is limited by the Second Amendment, as interpreted by the Supreme Court, and applied to the states through the 14th Amendment. Third, the controlling test currently centers on historical tradition rather than interest balancing. These principles affect ordinary citizens in concrete ways. Whether you are a gun owner, a policymaker, or simply a voter, the constitutional framework shapes what laws your state can enact and enforce. Consider how this plays out during election cycles. State legislators may campaign on promises to expand or restrict gun rights. But regardless of political platforms, enacted laws must survive constitutional scrutiny. Courts serve as the arbiter of those limits. This constitutional dialogue between legislatures and courts is not a flaw in the system. It is the system. The separation of powers ensures that fundamental rights are neither absolute nor easily overridden. As we approach the end of this discussion, I want to bring it back to fundamentals. The debate over state gun laws is not solely about firearms. It is about how we interpret the Constitution. It is about the balance between national rights and state authority. It is about whether history constrains modern governance. If there is one myth to discard, it is the idea that the Constitution provides simple answers. In reality, it provides principles that must be interpreted, applied, and sometimes contested. So what are the three most important takeaways? First, the Second Amendment now unquestionably limits state governments. That was not always true, but since McDonald v. City of Chicago, states must respect the core individual right recognized in Heller. Second, the Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin fundamentally changed how courts evaluate gun regulations. The focus is on text and historical tradition, not on judicial balancing of policy interests. Third, the constitutional limits on state gun laws are real, but they are not absolute prohibitions on regulation. States may regulate firearms in ways consistent with historical precedent and long-standing traditions, particularly when addressing public safety concerns within recognized boundaries. Understanding these principles matters. It matters because constitutional law shapes daily life, often in ways we do not immediately see. It matters because rights and regulations coexist within a structured legal framework. And it matters because informed citizens are essential to a functioning constitutional republic. The next time you hear about a new state gun law being passed or challenged, you will know the deeper story behind it, the centuries of constitutional development, the post-Civil War transformation, the landmark Supreme Court decisions, and the ongoing debate about history and modernity. The Constitution is not self-enforcing. It is interpreted, argued, and applied by courts, lawmakers, and citizens. And its meaning evolves through that process. Thank you for engaging thoughtfully with this complex and consequential issue. If you found this analysis valuable, continue the conversation below. Constitutional law belongs to all of us, and understanding it is the first step toward participating meaningfully in it.